Well, good morning, Texas. I see a lot of friendly faces and names out there. I'm glad we get to hook up today and talk a little bit about the basics of POA law. Let's see here. Give it another couple seconds and then we'll go ahead and get started. Well, we've still got folks streaming in. So, quick introduction for myself. My name's Clint Brown. I'm an equity shareholder with our law firm, Roberts, Markell, Weinberg, Butler, Haley. I kind of help lead our POA practice across the state, and I am board certified by the Texas Board of Legal Specialization in residential real estate law, as well as community association law, which is what we're going to be chatting about here today. All right, let's get going. So, of course, attorneys, we love our disclaimers. So, the information I'm chatting about today is based on the law as it exists today, February 24th, 2026, and the information is being presented for educational purposes. It doesn't constitute legal advice. If you need legal advice, please consult the association's legal counsel. With that said, I love hypotheticals, right? Use some air quotes on that. Just know that the information or thoughts I give, not legal advice. It's more educational in nature. So it's always good to get that firmed up legal opinion from your counsel. But hopefully I can provide a little bit of education to y'all and answer some questions. So what are we talking about today? Let's get into the agenda. We're going to talk a little bit about our property code basics. So kind of the distinction between a single family community and a condominium community. And that's because the law recognizes and distinguishes between those two types of community associations. We're also going to talk about open records, open meetings, how to amend your deed restrictions, your declaration, and then we'll get into hearings. And I'm going to do a quick sidebar here. These subjects, I could probably spend 2 to 3 hours talking about. I promise we're not doing that today. It's going to be 1 hour, and I'm going to do my best to limit it to 50 minutes so that we can have about 10 minutes for Q&A. And look, if we go over that 10 minutes and we still have a few questions, I'm okay hanging on for a little bit longer as long as y'all are. So with that, let's get in the weeds. All right, so here are some very important chapters of the Texas Property Code. And again, it's one of these cool little books for condominiums and one of these books for single family communities. And those books are also available on our website if you want to download one. So you've got a nifty PDF with all these important chapters in it. So chapter 81, nifty, golly, I think that may be a term of art from the 50s. I apologize. Chapter 81 of the Texas Property Code applies to condominiums who either haven't adopted chapter 82 through an amendment to their declaration or whose declaration was recorded before January 1st of 1994. So if you're a declaration or you're a condominium regime from the 80s, early 90s, before 1/1/94, and you haven't amended your declaration to adopt Chapter 82, well then, Chapter 81 applies to you. Chapter 81 does not apply to any condominium whose declaration was recorded on or after January 1 of 94. So keep that in mind. And Chapter 82, again, it's Chapter 82 in its entirety applies to condominiums whose declaration was recorded on or after January 1st, 1994. Now, for those pre-94 condos, certain sections of Chapter 82 apply to you. Well, and you're like, Clint, how do I know what sections apply to me and what don't? So I'm just going to show you one little page here. You may be able to see there are bolded sections here. And so our book actually bolds the sections that apply to both Chapter 81 condos and Chapter 82 condos. So it helps gives you that guide. And as I mentioned, these books are available on our website. So fairly easy to get a hold of it and download for those condominium board members out there. And again, we've got a single family version as well. So that's Chapter 81 and Chapter 82. Chapter 209 of the Texas Property Code only applies to single family communities. And then finally, the other big chapter we use a lot is Chapter 202 of the Texas Property Code. That applies to everybody, condominiums and single family communities. All right, so common terminology I'm going to be using today. When I say POA, the term of art means Property Owners Association, and it applies to condos and single family. So if I use the term POA, that is a legal term of art defined in the property code to include both single family communities and condominium communities. When I say COA or condo or condominium, obviously that's a condominium association. When I use the term HOA or single family community, that references single family homes. Okay, so condominiums. What makes a condo a condo? The big thing that you need to remember for condominiums is that no individual owner owns the dirt. So your unit is on a slab and there's dirt under that slab. You do not own the dirt. That is one of the big things that makes a condo is that you do not own the dirt. So let's go through an example. We've got a 100-unit condominium community. It can be stacked units or not. It can be shared wall units. It can even be separate units where each unit is a separate structure, detached condominium regime. The dirt is owned in common by the owners. It is owned in common by the owners and managed by the association. So if you have 100 units that are equally divided on voting rights and allocated assessment interests so that everybody has 1% in a 100-unit condo, that means that you, the owner of unit 101, own 1% or a little piece of that pie, of the 100% pie, everywhere you step in the common elements. So you're in a grassy area. It's not that you don't get to say, well, I own the dirt right under my unit. That's my 1%. No, it's wherever you step, it's a 1% interest. So keep that in mind. It's fractional, but it's owned in common. And ownership normally is just your studs in, your studs in, your faucets, your washing machine, all that kind of stuff, and your airspace. And then again, the common interest, undivided interest in the common area. And the deed refers to a unit number. Here's some more information. The association doesn't own the dirt. Why? Because it's owned in common by the unit owners. So we don't own any property. We don't pay any ad valorem taxes on the association. And the common elements are owned in common by the owners, undivided interest. And again, as I hinted at, there are some condominium regimes, detached single-family condo regimes, that look like a single-family community. You're driving through and you see separate homes and you're like, wow, this is a single-family community. It's not. It's actually a condominium regime. So you don't own the dirt if you buy in that community. There are office condos, and we even have some communities out in Lake Travis and other lake areas where you're part of a dock condominium association. So it's kind of unique, but we see those at least in the Austin area and some of the areas in Houston as well. Okay, townhomes. This is a weird one in the state of Texas. Technically, a townhome can be a condominium. It can also be a single family community. So a townhome can be a condo or it can be an HOA. Well, Clint, how do you know? Your governing documents will let you know. So, biggest clues. Clue number one, look in the definition section of your declaration. If there is a lot, capital L lot definition, well then, that means the owner owns the dirt. Well, my first rule on condos is you cannot own the dirt. So that's indicator one, it's a single family community. If it doesn't use the word lot and instead uses the word unit with an undivided interest in the common elements, well, then it's probably a condo. Also, look at your deed. Is it a lot block description or is it a unit number description? If it's lot block, it's going to be an HOA, single family. If it's a unit, it is likely going to be a condo. And again, does your deed speak to an undivided interest in the common elements? And is there something in the declaration saying it's subject to Chapter 81 and or Chapter 82? Those are some helpful hints for determining whether or not your townhome is a single family townhome or a condominium townhome. Okay, so that's condo. Let's flip over to HOAs, single family communities. Community associations own the common area. It is actually in the nonprofit entity's legal name. One caveat is when you're under developer control, well, the developer may still own some of the common areas, but slowly but surely they typically convey that over to the association for ownership and maintenance obligations. Now, owners have an easement of enjoyment to the common areas. So every owner, as a dues paying member, has an easement to utilize the common area. But that easement right is subject to the right of the board to promulgate rules and regulations governing the common area. So even though you've got an easement of enjoyment as an owner, it is not unrestricted. The association is given the right as the owner of the property and manager of the association to implement rules and regs. So keep that in mind. Your plats, so plats for HOAs, it'll show individual lots, it'll show common areas. Your deed describes ownership as a lot and block. And again, we already hit on that. And finally, I touched on this, beware, you drive into a community and it looks just like a single family community, but lo and behold, it's a condominium regime. So if you're buying, make sure you're aware of what you are buying into, looking for those helpful hints that I mentioned in the prior slide. Okay. So that's kind of the difference between a single family community and a condominium community. Let's get into open records. Okay. So open records, an owner in the community has a right to receive and review the books and records of the association. Now for HOAs, i.e. non-condos, that statute is 209.005 of the Texas Property Code. Step one, it says you must adopt an open records and production policy. You must, not may, must. So you've got to get that open records policy in place if you do not have one. Get with your counsel to get one adopted. They are fairly cheap and fairly easy to adopt, and then you're statutorily compliant. There are records retention requirements in this section as well. How long do you keep your records, right? How long do you keep your records? It also goes into how an owner should make an open records request and the time frames that the association has to provide a response. And it's 10 business days with an additional 14-day extension as needed. And look, I'll tell you, here is the good thing about an open records policy. It allows the association to fee shift the cost to locate, compile, and reproduce the requested records. Now, the fees aren't much. I believe it's 10 cents a page and $15 an hour, but it does allow you to fee shift over to the owner to make sure they're serious. I can't tell you how many times I get an open records request where the owner is literally requesting 5,000 plus pages of documents, and it's going to take your manager or your board 50 plus hours to locate, compile, and reproduce. And so the law recognizes the idea that, look, you can fee shift a portion of that cost over to the owner before you have to produce anything. So that 10 business day, as long as you respond and saying, hey, you've got to pay for all this stuff, you've met the 10-day clock. When the owner provides you that information, there is a good argument that that 10-day clock restarts. So you've got that 10 extra days to produce once they pay, right? They've got to pay first. Now, it is a must to adopt an open records policy. Well, what happens if you don't and you get an open records request? Well, the law says you do not get to fee shift. No fee shifting allowed without an open records policy. That means the owner gets those records for free, and you've got to follow the statutory deadline for production. And look, big picture, if you need a little extra time, many times if you communicate with the owner, they'll agree to give you a little extra time to produce everything. So working with the owner to try to get that worked out is the way to go. But yeah, that is open records under 209.005. Okay, just some helpful hints. Attorney records, not an association record. There are the retention policy requirements with the statutory minimums. Retention policies are kind of unique because you really need to utilize it if you have it. So if you've got records that are over your retention policy guidance, you need to destroy those records so that you maintain a clean book and you follow what the law lays out for retention periods. If an association doesn't give the owner the records or provides incomplete records, or the owner thinks they're entitled to something that we say they're not, they have a right to file a justice of the peace lawsuit for noncompliance. They've got to give 10-day notice of their intent to do so, and it's got to be certified. But after that time, they can file a JP suit if they think that they're right and the association is wrong. Okay, so that was HOAs, right? Single family communities. Let's move over to condos. 82.1141, it applies to all types of condos. So both pre-94 and post-94. I'm going to use a term of art. It's called TUCA. TUCA is Chapter 82 of the Texas Property Code. It stands for the Texas Uniform Condominium Act. So TUCA. So this applies to all condos, both pre-TUCA and post-TUCA. And it more or less tracks single family law. A lot of it is almost exactly the same. So, required to adopt a policy, you can fee shift if you have a policy. If you do not have a policy, you cannot fee shift. Attorney records, not an association record under most circumstances. There are retention requirements for various documents. And again, if an owner thinks they didn't get what they're entitled to, or there's no response, they have a right to file that justice of the peace suit for noncompliance. So before we get into open meetings, one thing for both TUCA and for both condos and single family communities, owners have to make their request by certified mail. So if an owner sends you an email listing 50 things they want, and that's it they send, technically you do not have to provide them with the requested records, and no clock starts ticking. In order to trigger the law and the open records policy, assuming you've got one, they have to send the request by certified mail to the address listed on the association's management certificate. Okay, let's get into single family on open meetings. So this is HOAs, not condos. We're not talking condos right now. The relevant statute is 209.0051. Number one, association meetings must be open to your owners, subject to the right of the board to reconvene in executive session. Meeting minutes are required. There is a definition for what a board meeting is and is not, so keep that in mind. Meeting minutes, you must have them. Executive session meetings. So this is when the board adjourns their open board meeting and reconvenes an executive session. An executive session is when all the owners have to leave, and you've just got your board, you've got your management team, and you've got your legal counsel, if applicable. If applicable. And executive session meetings. You can't talk about whatever you want in executive session. It is limited in purpose and in scope. So it is limited to actions or considerations involving ... personnel, pending or threatened litigation, contract negotiating, enforcement actions, confidential attorney communications, and then individual owner issues where the owner has requested something to be private and the board has agreed to keep that something private. That is it. So if it's not one of those items, you cannot talk about it during executive session. So keep that in mind. Executive session is not a free pass to kind of discuss whatever you want. It is very limited in scope. Another kind of important topic about executive session I see a lot. Picture kind of two bubbles. We've got one bubble, which is your open board meeting. That's the big bubble. You have another one over here. That's your executive session. The executive session bubble fits inside the board meeting bubble. So it is not separate from the board meeting. It is actually a part of your board meeting. And so you basically adjourn your open session portion and you reconvene into the executive session portion. So technically you cannot have a board meeting that is just executive session. It is still a board meeting open to the owners. Now, if the only thing you're going to be chatting about is stuff in executive session, well, then your manager puts in the notice that this board meeting will immediately be adjourned into executive session. We do not plan to, address anything in open session except for a summary of our executive session discussion. And so that summary is required, must be summarized in open regular session and include any expenditures that you may have approved in exec. I don't like to approve expenditures in executive session. I prefer that you do that in open. I just want some transparency, and it can just get difficult if you start approving stuff in executive session on expenditures. So do your best to approve everything in open session. I also typically do not recommend meeting minutes for executive session. Why? Because executive session is supposed to be private. Meeting minutes should not be basically provided because it should be private. It should always be kept private. So if you want to take personal notes for yourself, you can, but avoid taking executive session meeting minutes. Okay, open meetings, HOA, single family. This page is gold, and Kyle will give everybody a copy of the PowerPoint a few days after today's session. Please print this page out. Print it out. If you're a manager, keep it at your desk so you're always staring at this thing. These are the 15 items that cannot be voted on outside of a board meeting. Rather, they must be voted on at a properly noticed board meeting during open session. Properly noticed board meeting during open session. And it's 15 items. I'm not going to talk about each one individually, but they're there. And so this is a great little tool for whether you're a manager or a board member, just to have handy so that you can look at it and say, nope, we can't vote on that thing outside of a meeting. We've got to include this thing in the agenda because we've got to be specific enough to meet this requirement. So remember, your notice of board meeting must say, consider and vote on levy of special assessment. Why? Because special assessments are one of the 15. Well, I've got a vacancy I need to fill. Consider and vote on filling of vacant board seat. So get specific on your agenda because that is what 209.0051 requires. And the questions are coming in on meetings. I think we'll be spending a lot of time on that during our Q&A, which is great. Open meetings. Okay, still on single family. Notice, date, time, place, general subject, including general description of executive session matters. That's what the law requires. And remember, if it's one of the 15, make sure you're listing it in your agenda. You can snail mail that notice 10 to 60 days before the board meeting. I'm not sure I've got one client that snail mails board meeting notices. What most people do is the second part. They can send it 6-day notice, so 144-hour notice to all members, or 72-hour notice for special board meetings. So regular board meeting is 6-day notice. Special board meeting is 3-day notice. Well, Clint, what's a special meeting for? Think of it kind of as your emergency. There is a reason you cannot meet the 6-day notice. You've got to get this done quickly. That's when your special meeting notice should kick in. Okay, how do you provide the notice? You have to post it either on your website or on your common area where you post notices, if you've got common area where you post notices. So it's either or. You can post it on your website or physically in your common area. And this is the and. So it's either or, website or common area for posting. And you must email it to all owners that have registered their email address with you. So posting on your web or common area and emailing to all owners who've registered their email with you. All right, that's single family. Let's talk condo. Condo is a little bit easier. I'll get into the reasons why here in a minute. Meetings of the association, so those are annual meetings, must be held at least once each year. I guess that's what annual means. Yes, once a year, annual meeting for condos and for single family, just a different section of the code for single family. Number 2, unless your declaration provides otherwise, special meetings of the association, right? So not board meeting, but member meeting, may be called by the president, number 1, by a majority of the board, number 2, or by unit owners having at least 20% of the votes in the association. So those are 3 ways to call special meetings of the association pursuant to 82.108. Okay, meetings are open to unit owners, subject to the right of the board to adjourn and reconvene in executive session to consider. And this laundry list is similar to single family, but it's got a couple different phrases. Actions involving personnel, pending litigation, contract negotiations, enforcement actions, matters involving invasion of privacy of unit owners, and then finally matters that are to remain confidential by request of the affected party and agreement of the board. That's your executive session items. That's your list. Don't go outside your list for executive session. All right, so virtual board meetings for condos. They can be held in person, virtually, or by phone, as long as you give notice of the meeting properly and every director, every board member can hear and be heard by every other director. And the virtual meeting or telephone meeting may not involve voting on the following topics: voting on a fine, damage assessment, appeal from an ACC denial, or suspension of a right of a member before an opportunity to attend a board meeting to present the member's position is presented. So if it's one of these 4 items, you must have a in-person meeting to consider them. Very weird situation, but it is what it is. That's what the law says. Okay. If the board acts by unanimous written consent, so you're outside of a meeting, you get 100% approval by the condo board, you can do it, but you cannot do any action that's on that list on the previous slide. So fines, appeals from a denial, et cetera, et cetera. So those items you cannot act by unanimous written consent. Everything else you can. However, the record of that unanimous written consent has to be filed with the minutes of the next board meeting. Okay, here's the funny thing about condominium board meeting notices. You don't have to give them to any owner in your community. There's no requirement to give them to unit owners. You're only legally required to provide them to each board member. So if you're a board of 3, you technically only have to give notice of the board meeting to those 3, unless an owner requests notice of the next board meeting. And if an owner requests notice of the next board meeting, the board has to do it. Otherwise, there's no requirement. Now look, sidebar, that's what the law requires. Should you give notice of board meetings to your unit owners? Yes, I think you should. I think it's a good practice to give notice to your unit owners. I just wanted y'all to be aware that the law does not require that unless an owner requests notice of the next board meeting. I told y'all this is a lot of info. I mean, you know, here we go. All right, let's keep going. Keep on keeping on. Single family communities. So we're talking HOAs here. I've got that cheesy 6767. You know, my kids told me that that's not cool anymore. So it finally got to a point where adults understood what the heck 67 kind of sort of means. And now it's not cool anymore. So I'm just called a nerd dad every time I make the old 6-7 joke, but it is what it is. All right, so let's talk amending your declaration. So again, it's the deed restrictions, your declarations, your covenants, your CC&Rs. I call this rule, and I'm going to talk condo law as well. I call this the ceiling rule, or excuse me, the roof and floor rule. Roof and floor. So let's talk single family first. Every single family home in Texas, you've got a roof, right? You've got a roof. It's a single family home. There is a roof over your head for a single family community, directly over your home's head. So think of single family as the roof rule. That roof is 67%. The roof is 67%. That means in order to amend your declaration, it can be any percentage up to 67%. So if your declaration says you need 75% approval, well, you're above the roof. That's not allowed. That is not permissible. And so the law drags that 75% down to 67% approval of all owners. So that is the roof rule. So think of roofs, think of single family homes. That's the roof. Okay. The floor applies to the condo. This is the floor rule. So floors. Not all condos have roofs, right? Because sometimes in a stacked condo, your roof is actually the unit above you, so it's not technically a roof. So the roof rule doesn't apply to condos. But condos all have floors. They all have floors, even if they're stacked. And so the floor rule says this: you cannot go below 67% to amend your declaration. So if your declaration for a condo says 50%, well, the law actually ratchets that 50% up to 67. So 67% is as low as you can go for condominiums. 67% is as high as you can go for single family communities. So that is the roof and floor rule that I like to utilize when I'm talking POA 101. Now, there are exceptions, always exceptions. We kind of throw the 67% out the door when we're under the developer period, because most documents say that you've got to get developer's approval. Sometimes it says only the developer can amend the declaration during the declarant control period. So just keep that in mind. If you're under declarant control, this rule doesn't really apply to you yet. It will once declarant control is over, but for now, it really doesn't apply. Okay, so this is 82.067. This applies to TUCA condominiums, so post 1194. And again, think the floor rule. And you are stuck with 67%. And the only way you can have a lower number than 67 is if all of the units are not residential. Most people on this call are parts of residential condos, so remember that floor rule. And here are some exceptions to how to amend your declaration. You cannot, it's more difficult if you want to create or increase special declarant rights, increasing number of units, the list goes on and on. So if you want to do any of those things, you likely have to get 100% of all your unit owners to approve an amendment. And again, this is condos post 1994, post on or after 1194. So TUCA condos. Just some more examples. Let's keep going, Kyle, because I want to get to the questions. All right, so pre-TUCA condominiums, so condos whose declaration was recorded prior to 1194, you look at 81.111, and it says at least 67% of the ownership interest to approve. So at least, so it's that floor rule again. Okay, so that is amending your declaration for condos and single family. Let's get into hearings. This section applies to all condos, both pre-TUCA and post-TUCA. 82.102A12 basically says, hey, you can levy a fine. But before you levy a fine or charge for damage, you must do this. You must send a letter that describes the violation and amount of fine or damage charge, gives the owner 30 days to request a hearing, gives the owner a reasonable time to fix the violation and avoid the fine, and you don't have to send another letter if the same or substantially similar violation occurs within a 12-month period. So in month 1, you send a letter to a unit owner for, parking not in their designated parking spot. And they fix the problem in 15 days. So you send it in January, they fix it in 15 days. Well, March rolls around and they do it again. Well, at that point in time, you can immediately fine in March. In January, you had to give them an opportunity to cure before you fined. But because they did a violation again within a 12-month period, i.e. 2 months later in March, you can levy a fine immediately. So that's how the 12-month window rule applies for condominiums. Oh, and then one other point on condos, after you levy the fine, you must send them another letter notifying them that they've just been fined. So you have to send 2 letters, right? One letter giving them a reason, telling the violation is this, you've got a right to a hearing, you've got a reasonable period to cure. And then after you levy the fine, you have to send another letter saying, hey, we just fined you, and we're going to fine you more unless you cure the violation. Okay, let's go over to HOAs, single family communities. The relevant section is 209.007 of the Texas Property Code. And a lot of y'all probably know this backwards and forwards. You've got to send out that certified letter. It's called the 209 violation letter. You have to describe the violation. You have to tell them what the fine amount will be, give them a reasonable period to fix the violation unless it is uncurable. And we'll talk about that in a minute. So they can fix the violation unless it's uncurable. And then you have to give them a right to a hearing within 30 days of the date of the letter. It's got to be requested within 30 days of the date of the letter. So they request a hearing on day 25. Well, from that day, day 25, you've got 30 days to hold a hearing. Number 1. Number 2, you must give an owner a violation hearing packet at least 10 days prior to the hearing. What the heck is a packet? Think of it like your evidence. So what's in your evidence? Pictures, copies of the violation letters, a copy of the declaration that they're violating or rule and reg that they're violating. That's it. Should take you about a minute to put together your packet. Just remember, you've got to give them at least 10 days prior to the date of the hearing. If the evidence is not provided, the owner is entitled to a 15-day postponement. That is their remedy. They get a 15-day postponement. So it's not like, oh, you missed the hearing packet deadline, so I never have to comply with this violation notice again. I get a freebie. Nope. Owner doesn't get that. They get a 15-day postponement, and obviously the board will need to properly provide a hearing packet. Hearing, again, 30 days of receipt of request for a hearing, 10-day notice of the hearing date, time, and place with your packet. And then, look, most of the time you can work with the owner and come up with a hearing date that works for everybody. And then these timelines really don't apply because the parties have agreed. So work with your owner. Be nice, give them the hearing packet, try to come up with a date that works for the board and the owner, and that way you don't really have to worry as much about all these timing requirements. But just keep them in mind as you're working through the hearing request. And there are exceptions to the hearing request, but general rule, you've got to give it. Okay, so uncurable fines. Those are fines that are incapable of being cured and or are a threat to the health or safety of an individual. On uncurable violations, you can immediately fine. You do not have to give a reasonable opportunity to cure. Why? Because it's not capable of being cured. Most common examples, these are statutory, fireworks, threat to health or safety, noise that is not ongoing. So you have a massive 4th of July party and it gets crazy. Well, that party, that noise, uncurable. Property damage, garage sale. Those are all uncurable examples. Curable, parking, maintenance, plan inconsistency, so ACC's type stuff. And then an ongoing noise. So you've got a dog that barks every night. That's ongoing. That is not uncurable. That is curable. Oh, I did good. I've got roughly 15 minutes left, but I think we've got a lot of questions coming up, Kyle. So in conclusion, remember the property code chapters governing POAs. There are significant statutory differences between HOAs and condos. And again, I'm not expecting you to be a law savant, but having a basic knowledge of the law can really save from headaches down the road. And remember, a lot of times these chatbots that are utilized get it wrong. Why? Because they look at other states' law and actually incorporate it into Texas law. And it can give you more of a headache down the road if you're not careful. So keep that in mind. I know chatbots are getting better and better, though. AI is getting better and better every day. All right, finally, a plug. If you like us and you're one of our clients, please leave us a review. We love Google reviews. Don't give me 1 stars, though. I know today was a bad presentation, but if I could get a few more stars than that, that'd be great. No, not forcing this on y'all. Just something to think about if you like the service we provide you. All right, let's get into Q&A. Here we go, Kyle.
All right, Clint, we'll start with the one we got emailed yesterday. So this is from Tom. And Tom asked, revolving to around 209 records request process, does the demand for prepayment of estimated records production costs toll or reset the statutory response deadlines? Or do the deadlines still run from the date the records request is received? He continues, if the advance payment request suspends the response clock, where in the property code does it protect a requester from a POA informing the requester that the prepayment is required, but then purposely delaying the provision of the estimate indefinitely?
They don't get to delay indefinitely, right? They've got 10 business days to provide you with the estimate, or there's a good argument that the documents are free. So you don't get to say, oh, you've got to prepay, but I don't know what that number is. You've got to give them a response with the amount. And then once the amount is paid by the owner or requestor, that's when that 10-day clock triggers again. So there should be some protections there.
All right, we're going to go to meeting minutes next. What specific things are required to be in the minutes and what should not be included?
Robert's rules talks about meeting minutes only having the actions taken, right? Not discussion, not open forum, actions taken by the board. In terms of voting, I like to see whether or not it passed by majority or unanimous. You can give a count: 4 in favor, 1 against, 3 in favor, 2 against. I tend to like to avoid using names. Why? Because it can be used in litigation down the road. I like just kind of general topics. In terms of actions taken, yes, you can get specific on the actions taken. So the name of the contractor, the price of the contract, you could include the other bids that you considered. So that's Robert's rules. So if you were following Robert's rules, it would be meeting minutes that are no longer than 2 pages. With that said, I've got some boards that want to provide a little more information, right? They want to get into how people cast their vote and why. They want to have notes on open forum. I'm not necessarily opposed to that. Just understand that that can affect you down the road if there is ever litigation involving you and you've got to produce all these meeting minutes. So just, keep that in mind. I prefer short is best, but I'm one of those darn attorneys that likes to reduce liability for my client as much as possible.
All right. So question on if we'll be sending out the PowerPoint. Yes, we will be emailing out the PowerPoint to all attendees. We'll also include a link to the video in the next few days. So I know there's some requests later on to get that video out today. I will try to get it out today as soon as possible. So following up on minutes, why don't you want to take minutes during the executive session?
Because I'm a mean attorney and I don't like them. No, so again, executive session by its very definition is supposed to be private between the board. And if you are promulgating minutes that get utilized over and over and over again amongst your board members, something's going to happen. And that document is going to accidentally be produced. And the minute it gets produced, that puts you in a lot of hot water because a lot of those topics discussed in executive session are legally required to be private. I mean, you're invading somebody's privacy if you're talking about an owner's collection account, or maybe you're considering a disability where an owner needs a reasonable modification or accommodation, or maybe you're discussing Clint Brown's legal opinion. So minutes just really, it's a recipe for disaster down the road. I'm okay with you taking personal notes that are not association books and records, but that's kind of leads me into my point number 2 that I talked about earlier. Have your official voting during open session. And if it's something sensitive like a collection account or a violation account, just don't mention the owner's name or address. Mention maybe the last 4 digits of their account number, or speak generally about them, so that you still have the action reflected in meeting minutes. You just don't have these executive session minutes floating around that could accidentally be divulged to your community or the public.
All right. Next question, will your team be able to hold any training on ACC? I do believe we do have some training on ACC lined up for later in the year. If you go on our YouTube page, you can see past videos that we've done from last year that are up to date on the laws. So those get you through in the meantime till we get that on the books. All right, talking of ACC appeals and foreclosure action. Being in an open meeting, how do you keep that as a private matter for the homeowner if they are present to address the board?
Just gave the answer, right? So discuss it during exec, right? I'm fine with y'all getting into the nitty gritty during exec, but then adjourn back into open and vote on, I make a motion that account numbers ending in 1, 2, 3, 4, 8, 9, 10, 11, 12, 13 be referred to the association's attorney for further collection action, including foreclosure lawsuit. Done. Second, approve. That's it. So you haven't disclosed the owner's name, you haven't disclosed the owner's address, but you've got an identifying number that only the owner, management, and your counsel know. And so there is no disclosure of private confidential information. So that's one way to do it.
All right. On executive session, can it be held 30 minutes prior to the meeting, the board meeting starts? And where do you go into the board meeting? Where you go into the board meeting directly following executive session?
So remember, we talked about the bubbles at the beginning. You've got your board meeting bubble and you've got your executive session bubble. They are not separate. The executive session bubble is inside the board meeting bubble. So you have to open a board meeting, a regular board meeting, and then you adjourn that meeting and reconvene in exec. So remember, it is not 30 minutes before the board meeting. It's at the board meeting, and you tell your owners, hey, first 30 minutes we're having exec. Just a heads up. You're welcome to hop on the call, but we're kicking you out immediately, so that the owners know that the open session portion of the board meeting will start at this time, so that you are being respectful to your ownership, so that they know when the open session portion starts. But remember, they are not separate, they are together. The executive session is within the open session.
On the 6-day notice for meetings, does it include weekends?
It does. It does. It's not business days. It is 1 44-hour notice, which includes weekends.
All right, next question. I have a new to me community who always voted on foreclosure in executive session and then ratifies the foreclosure in a next open board meeting, in this case 2 months later. I've informed them that it's not legal. They claim they've always done it this way. I'm assuming if the owner challenged the foreclosure in this arrangement, it would be thrown out on a technicality.
Yeah, that's a good question. And I think, there are different ways around the issue, but again, best practice, vote on it during open session. And the response I get is, Clint, our executive session is at the end. When we go back into open, there's not going to be anybody there. Well, that's fine, but follow the letter of the law. Reconvene in open and vote on the foreclosure action in that meeting. Don't wait until the next month to quote unquote ratify it, because that's technically not what you need to be doing. So follow the rules, vote on it in open. And again, there are exceptions to that rule. Maybe your collection policy gives automatic referral authority to the attorney to institute foreclosure immediately. And so that could be a way to meet the foreclosure requirements found under 209.051. I'd spend 20 minutes talking about that subject, but there are other options. But again, best practice, do it during open,
Right.
without disclosing owners' names or addresses.
All right, next question. For open meetings, suspension of the owner's right is listed as something that needs to be completed. Would this apply to an amenity suspension for a violation of HOA rules and policies as well? If so, does the suspension officially start the day it is passed in an open meeting?
So again, this is condos, not single family. So we're just talking condos, and it's 82.108. You've got to give an owner the opportunity to attend a hearing before you institute the suspension action. And if your fine policy, which is adopted at a board meeting during open session, says you can suspend for any violation, well, then you just need to wait that time period for a hearing. But if an owner requests a hearing within that 30-day period, you need to have that in-person board meeting prior to suspending their access to the association amenities. And keep this in mind, you need to see that suspension authority in your governing documents.
All right, next question on executive sessions. If they are held on Zoom, should they be recorded?
No.
All right, so next question. Yeah. May executive session be held by electronic means that is not contiguous with the association meeting, then summarize that association meeting?
My, oh my. be held by electronic means that is not contiguous with the, I mean, I guess a separate Zoom link. Yeah, I'm fine with that. It would just be like an executive session Zoom link kind of a thing. And then you go back into open session when you're done on the first Zoom link. Yes, I'm okay with doing it that way.
All right. If one of our community documents expressly states an annual meeting is to be held in a particular month, can the annual meeting be held in a different month, as long as it's held annually, regularly, and during that same month?
I don't recommend it. Your bylaws say in the month of May every year. It needs to be in the month of May every year. Clint, that's really hard to do. I understand. Let's amend your bylaws. Many times the board can amend its bylaws without a vote of the owners, i.e. the board can do it, not the owners. 22.102 of the Texas Business Organizations Code allows the board to amend its bylaws. And then if we're talking about a condo, 82.102A1 of the Texas Property Code also allows the board to amend its bylaws. There are exceptions to that rule, but that's the general rule of thumb.
Right. Next question. Could you share an example of properly written agenda using consider and vote and with an executive session?
So the executive session agenda would just list the things you're going to be chatting about. And look, I like to cut and paste what the executive session topics are from the code. So 82.108 for condos, and then 209.0051 for single family. That's your executive session agenda. And then, it's just consider and vote on, and then your stuff. I mean, I'm comfortable with it, even if it doesn't say consider and vote on, but maybe using that as your template for executive session so that you're covered.
All right, next question. In government, who's responsible to enforce Chapter 209?
Nobody. So it's the association's obligation to have legal counsel and management that are going to effectively comply with 209. And then if an owner feels like a association is not complying with 209, there is a statute that says you get to sue. You can sue the association.
All right. So next question. This is appropriate because our next webinar in April will be going over this topic. If a community is in the process of transition and the majority of the board is still with the declarant, do you still need a unanimous vote from the board, or are all determinations still under control of the declarant?
Okay. Well, and back to that government thing, I guess thinking about it more, your government would be the judges, would be the court system. So that's the government that enforces. It's, through a lawsuit. Next, on this other question, we've got transition from declarant control to owner control. Unanimous vote. Oh, yeah. So this is a good question. We'll do single family. 209.0051 does not apply to communities under declarant control. So all the 0051 requirements I mentioned do not apply to declarant controlled communities, except for certain limited actions. And those actions, I should be able to tell you quickly, are actions involving adopting or amending a governing document, including declarations, bylaws, and regs, increasing the amount of regular assessments, or adopting a special assessment, electing non-developer board members, or establishing a process by which those members are elected, or changing the voting rights of members of the association. So if the developer wants to do one of those four things and wants to do it while wearing their board member hat, they must follow the open meetings requirements that I discussed. Otherwise, there is no requirement to.
All right. So basically just answered that one. So skipping through. Yes, we will share a recording of the meeting. So next, many homeowners do not know the meaning of the word cure. Can notices include a parentheses to simplify the word cure, such as cure, parentheses, correct violation?
Read that one more time.
So this person's asking if you can further expound on the word cure and the notice the violation of notice.
Yeah, so you know, you should have two letters. One is called the curable letter, one is called the uncurable letter. And you just kind of have to use common sense to the best of your ability. A curable violation is something that is capable of being cured, remedied, where you can kind of make it go away. So mowing your grass, that's curable. You paint your house purple and the association wants you to paint it whatever the appropriate color is. That's curable. Your fence is in disrepair. That's curable. Uncurable, things that are incapable of being cured or are a threat to the health or safety of the community. So somebody is, you know, operating a chemical lab in their garage. That's uncurable. Why? Because it's a threat to the health or safety. You get to fine immediately. There is no cure period. The other example I gave, somebody having a blowout, big old party, 4th of July party. You can't cure that. Somebody has, you know, damaged the front monument. That's not capable of being cured. You can't put the monument back where it was. You've got to rebuild the whole thing. So that is uncurable. So it's just kind of understanding curable versus uncurable. And you know, I guess you could say you have to correct the violation by this time. You don't technically have to use the word cure.
All right. It's 12:31, Clint. You want to go another 4 or 5 minutes?
Yeah, so does the hearing requirement of 209 apply to developer-controlled communities? Yes, it does. So you still have to give 209 hearings. On the packet, what if you include all of that with the 209? Yeah, so again, your packet is pictures, any emails you want to use against them, the relevant document you're trying to enforce, and then all the letters you sent them. That's your packet. What if a hearing that you want to have with an owner is only a 3-day notice? Can I provide the hearing packet then? No. The law says 10 days, but here's the but. If the owner agrees and says, yeah, this works for me, thank you for the packet, then y'all entered into an agreement. And what you need to do at the beginning of your hearings, just kind of get into the habit of this and saying, owner, we're having this hearing on your behalf. You requested the hearing on this date. We provided the packet on this date. I want to confirm that you're in agreement with everything we've done and that this is your 209 hearing. Yes, I agree. There you go. Now you've got an owner acquiescing and agreeing to the hearing and everything you've done up to the hearing. So that will get you in good shape. So hearings, you know, I think we've probably got an hour presentation that just talks about hearings. We're talking about violation hearings here today, but there's also credit reporting hearings and ACC appeal hearings. I'm going to limit it to violation hearings right now. Yes, so the violation hearing can be held during executive session, but if an owner says, I want it in open, and the association agrees, I suppose technically you could have it in open. But without that agreement from the owner, it should be held during executive session for your violation hearing. I won't get into the other hearing types because we don't have time and I don't want to muddy the waters. So again, I'm only talking about deed restriction violation hearings. Okay, regarding hearings, does the hearing notice in the packet only apply to hearings that the association schedules for the owner to attend, or does it apply to hearings that the owner requested? So if the hearing is at the request of the owner and there's no 209 requirement to hold it, right? You haven't sent your 209 letter, then there is no statutory rule on how to conduct the hearing. Rather, it's just a meeting between the owner and the board. But if you send a 209 letter and an owner requests a hearing within 30 days of that 209 letter, those hearing requirements that we chatted about apply. So you have to follow them unless you and the owner agree to some sort of sidebar agreement. And I think we're 5 over. We still have a bunch of questions. I'm sorry. They're great questions. And if y'all want to follow up and really need a question answered, please feel free to shoot an email to Kyle and he'll send that my way where I can help you as much as I can help you. Well, hey y'all, thank you so much. And again, I mean, the stuff we went over today really is a 2 to 3 hour session, but we were able to pack that into an hour. And if y'all ever want something much more in depth, we can do that, right? We're always open to thoughts and comments. And just wanted to say thank y'all so much for showing up today and participating. We had some really good questions, and I hope you enjoy the rest of your February. March is right around the corner, which means spring break, it's a coming. Let's hope TSA opens those pre-check lines here soon, or it is going to be a mess at the airports for those of you traveling. Otherwise, stay safe. Bye, everybody.